Good afternoon, and thank you for joining us. My name is Jim Rizzo, and I'm the Chief Legal Officer for the National Association of Home Builders. We are certainly living in very interesting times. The COVID-19 pandemic has dramatically altered the rules of the game for the nation's employers, and NAHB's members are no exception. Because so many of NAHB members are small businesses, it's not surprising many of the underlying laws concerning leave are unfamiliar to them. Laws such as the Family Medical Leave Act have traditionally not applied to small businesses. But with the enactment of the Families First Coronavirus Response Act, or FFCRA, this is no longer the case. NAHB is pleased to offer its members this opportunity to hear from two national experts in this field. Barbara Hoey and Mark Konkel are both partners at the law firm of Kelley, Drye, and Warren, and co-chair the firm's labor and employment practice. Mark and Barbara will provide us with an overview of the new paid leave provisions in the FFCRA, focusing on what this will mean for small businesses and the residential construction industry. NAHB will continue to provide information to our members to help you navigate the new economic and employment landscape of the global pandemic. We encourage you to visit www.nahb.org/coronavirus regularly for articles, webinars, and other resources. Let me now turn it over to Barbara and Mark.
Thank you, Jim. And greetings, everyone. I hope you're all well. As you can probably tell, we are transmitting this remotely. I'm in my home, Mark's in his home, Jim is in his home, and this is a little bit of a technological challenge for us because it's not how we usually do our webinars, but we've done it this way a couple of times now and it works. But if anything doesn't go totally well, I hope you'll all be patient. So look, as Jim said, this COVID-19 situation is changing like literally every day. Business closures in multiple states. The Families First Act actually goes effective today, April 1st. All over the country, most schools are closed. Employees don't have childcare. They're trying to homeschool and work from home or go out to work. Non-essential businesses, your workforce is remote because you can't let them come into the office or the workplace. Essential businesses, you have employees who are trying to avoid work because they're afraid to come in. So you might need them on a work site and you can't get them there. And you don't know when you're supposed to give them leave. And we don't have any idea how long this is going to last. As the last estimates we're getting, it could go well into the month of May. So we are going to cover the FFCRA, understanding that many of these W are under 500 employees. We're also going to cover any larger companies, non-FFCRA, because it's not the only law that's out there. And the other laws have not gone away. They're just overshadowed to some degree. We're going to talk about managing a remote workforce, which I think a lot of us, including my law firm, is doing. We now have over 300 lawyers simultaneously working remotely. Special considerations for essential businesses and things you need to think about if you have to make what I know are very tough decisions to undertake furloughs or layoffs, and try to do that in an hour. So this is not going to be, this will be a pretty jam-packed presentation. I will start by saying that we will try to answer as many questions as we can. We're not going to sign off immediately at the end of an hour, but if we don't get to a particular question, we encourage you to contact us after because it's been impossible in these presentations to get to everyone's questions. So the Families First Act, it was passed just 2 weeks ago, goes into effect today. It applies only to employers with under 500 employees, and we're going to cover how you count that number. Essentially, it's got two simple provisions. Simple in the enactment, maybe not so simple in putting them into effect. You have to give employees up to 10 days of paid sick days, and we're going to go over this in more detail. It applies to everyone who works for you, even if you hired them, March 1st, the day before the law was enacted. If they are quarantined, having COVID-19 symptoms or have children in school or in a daycare that's closed. There's also a new paid FMLE leave provision, 10 weeks of partially paid leave for employees who have a child care issue. And I'm going to do a deeper dive on that for a moment. So who's an employee? Who counts if you're trying to figure out if you're over 500? If you know you're under, this is not going to be that relevant to you, but do part-timers count? Do employees out on leave count? Do temporary employees count? And what about day laborers who are supplied by a temp agency? Yes, they all count as employees. So if you're close to that 500 threshold, just be aware of who counts when you're counting up your employees. Do independent contractors count? No. So if it's a true independent contractor, and that's a tricky test, you do not have to count them in counting whether you are over or under the 500. What about related entities? We've gotten a lot of questions on that. So maybe you have a parent company and you are a subsidiary of a parent company, or you have multiple subsidiaries. Are those related entities considered one employer? In most cases, no, but note we have the ever-present legal term, maybe. There are circumstances where a parent and subsidiary could be considered one entity. Again, this is getting pretty legalistic. I apologize. We're lawyers, but if you are really at or close to that threshold, I would encourage you to consult with legal counsel before you make the final decision. So you have to either meet what's called a joint employment test or be considered an integrated employer. So what do those tests actually mean? Integrated employer actually means kind of what it says. It's English. I mean, lawyers are known to speak English at times. If you are two separate entities, but common management, you have interrelation between operations, you're sharing employees possibly, you have shared finances, you have centralized control, so you have one management team and they're making hiring and firing decisions for the two entities, you're probably an integrated entity. And so the parent and the subsidiary would count together, and you might go over the 500 threshold and not be covered by the FFCRA statute. Two unrelated entities. So these are two entities like Company A and Company B. Typically, this is a company like the Smith Company and a temp agency that might be supplying you with workers. There are circumstances in those cases where you could be considered joint employers. And again, you could be on two payrolls, or you could have these employees on two payrolls. It matters who is controlling the terms and conditions of employment. So if you want to break the 500 threshold and you have a bunch of different entities, consider whether you want to try and glom them together and say, okay, we're over 500. On the flip side, and we're going to talk about this a little more later, think about the other implications, all right? And there are a number of them. One of them is wage hour, Fair Labor Standards Act, taxes, talk to your accountant. I mean, if all of these entities are considered separate for everything else, and you're going to glom them together to get out from under the FFCRA, you could be biting off your nose to spite your face, is something my grandmother used to say. So you got to think about all the implications.
Right. And you know, just a couple of quick points on that. One of the things I will often tell employers when you're trying to consider is there an integrated enterprise here? Are there two, technically separate employers who are a joint employer? A lot of the enforcement agencies will say to themselves, okay, stand in the shoes of an employee. When that employee goes to work, would that employee understand that Company A is a completely separate company from Company B, or is there common management, common control? Do I feel like when I'm working for one or the other that it's really working for the same company? And as Barbara says, don't let the tail wag the dog. We do a lot of wage and hour class actions where plaintiffs' firms love to glom together as many companies as possible because that's a bigger litigation target. So I think we're on to the next slide. All right, so what exactly does the FFCRA require? And the headline news that we've all read about is paid sick leave. Who is eligible? Pretty much everybody, right? So within those categories of employees that Barbara just talked about, your first day on the job, if you're an employee, you're eligible for paid sick leave under the FFCRA. What are the circumstances? You probably have all found this using the wonders of the internet already. But if you're under a quarantine order that's being imposed by federal, state, or local authorities, if your doctor or some other healthcare provider tells you to self-quarantine, dealt with an issue just like that this morning, if you're seeking medical diagnosis because you think you have COVID-related symptoms, or if you're caring for an individual who is also subject to quarantine. Now, one question that actually came up before the presentation even started is, if a business is ordered to be shut down, in other words, if there's essentially kind of quarantine or shutdown order for a business, is that the same thing as an individual being ordered to self-quarantine or being subject to a quarantine order? No, it's not the same thing, right? So the FFCRA is extending benefits to employees. There may be knock-on effects of employees of a lot of stuff that's going on, including business shutdowns. That's not, at least not squarely in terms of what we're talking about now, the FFCRA covers. So what do you get? 2 weeks of full paid leave, or the equivalent of 80 hours. And then for part-time employees, you prorate that. Note, that is in addition to your existing sick leave policy, right? That is on top of an existing benefit. I think you can go to the next slide, Barbara, because I can't switch them here from me. In addition to the paid sick leave portions,
It's so exciting as a woman to be controlling the slides. I
know.
never get a controller.
We try to empower you in whatever way we can. I'm helpless.
I
am helpless to deliver this presentation without your physical intervention, Barbara. In addition to the initial 2 weeks of paid leave, there is also a significant expansion of FMLA leave. So for the next 10 weeks, after that 2 weeks of paid leave, there are 10 weeks of paid leave, generally speaking at a rate of 2/3. The reasons are different though, so just note that last bullet. That only applies if the employee is unable to care for a minor child because the kid's school has closed, okay? So think of it, paid leave, the first 2 weeks has to do with whether you're directly impacted because you're sick or subject to a quarantine order or seeking a diagnosis. The extension of the FMLA benefits deals with some of these tangential effects of the overall shutdown. I hate to say next slide, but next slide. Okay. There is a small business exemption if you're under 50 employees. Now note though, that applies only where the employee is requesting leave for school or a place of care like a daycare closure due to COVID-19 related reasons. So how do you take advantage of that exception? Well, an authorized officer can claim the exemption if providing leave could, and this is the language of the statute and the guidance, jeopardize the viability of the business if it would result in, you can see those three circumstances there, right? Mm-hmm. So expenses and financial obligations exceeding your revenues, substantial risk to the financial health or operational capabilities of the company, or just can't staff people, insufficient workers. Now, obviously, there's a whole lot of leeway in things like, look at reason number 2, just as one example. Substantial risk to the financial health or operational capabilities of the company due to specialized knowledge or skill. I got to tell you, in terms of the employers that Barbara and I work with, I've never known an employer to say, I don't need somebody to come to work because they're really not that important. They don't know that much. We haven't trained them. It's fine. Just let them not come in. So the question is, how do you really take advantage of this exception? Exemption rather. I think what we're telling employers is, go ahead, make your good, objective, grounded business reason. Have an authorized officer of the company be able to articulate that reason in a clear and objective way. But in terms of enforcement experience, none of us has dealt with this before, right? We've never had these characterizations.
I'll give you an example that I think you could apply to construction. We represent a lot of medical companies. We had a large medical practice, like 40 doctors, where the one person who handles all of their IT infrastructure is asking for this leave. And they frankly could not function if this person is out. So they're applying for the exemption. Again, they do satisfy the under 50 employees. Do I know for sure whether that's going to satisfy it? No, but I think there's a really good shot at that. And I think if you had your chief architect or your chief project manager, and you're a small entity, and that's the key person or a key person, I think that would satisfy number 2.
Yeah, and look, there are also, obviously you have to build to deadlines, right? There are dates for deliverables and dates for construction project phases. If you're going to miss a deadline, there are going to be contractual consequences associated with missing that. That probably satisfies number one. So there are a lot of good reasons. I think the short advice here is be able to articulate to yourself in straightforward, objective terms exactly which of the reasons your circumstance fits into, and you should be fine under the exemption. Barbara.
Reinstatement.
Okay, so when that leave is over, so the first 2 weeks of paid leave and or the extended family and medical leave, what's the obligation? You have to reinstate the employee. There are exceptions for employers of less than 25 and 50 employees. It's another version of an exemption for small businesses. Normal FMLA exceptions may apply. So for example, if there's a key employee, right, that you absolutely have to backfill a position while a person is out. So there will be exceptions generally dealing with the impact to the business or the importance of a particular employee. But otherwise, there's an obligation to reinstate that employee to the same position when the leave is over. What's the risk if you don't? Well, that person is going to claim wrongful termination. They have a claim for back pay. They have a claim for benefits. And they have there are civil penalties associated with the violation of the anti-retaliation provisions under the FFCRA. All right, so let's take a hypothetical. We were dealing with Sick Sally here. She handles payroll for a construction company, lo and behold. She is exhibiting, let's say legitimately, COVID-19 symptoms. Doctor tells her, you know what? Testing's not available. Actually, this is the scenario that came up for us this morning. Testing's not available. I'm not sure if you have COVID or not. However, I'm going to advise you in writing to self-quarantine for 14 days. She comes back to work after 8 days. Turns out she did get a test and she's negative. And on her first day back, she is changed to a part-time schedule because the work dried up. You want to go to the next slide? What are the results here? Does she have a claim against you? She may, in fact, have a claim for retaliation. Why? That's because of what we said before. Under the FFCRA, an employer can't, it's not just terminate somebody, can't discharge, you see the words there, discharge, discipline, or in any other manner discriminate against an employee who takes leave. So in Sally's situation, she took leave. It's more or less the direct result of her taking that leave that she comes back to a changed employment status, right? Change to a part-time status. That's a material change to a term or a condition of employment. So we have to be cautious here not to overuse the exemption. You can't say, listen, we're just going to change this person's job. We need to adapt. We need to fire this person and backfill. In other words, don't let the exception swallow the rule, because under ordinary circumstances, there's an obligation to keep that job open, if at all possible. If you don't, that individual may have a claim of retaliation against you. There are some other employer obligations we want you to know about under the FFCRA. Can employees take intermittent leave? The short answer is yes. Just like, so we're talking about the additional 10 weeks of leave. Just like under the Family and Medical Leave Act, for those of you who may be familiar with that law, depending on whether an employee is exempt or non-exempt, that means not entitled to overtime or entitled to overtime, there's an ability to take time, not in increments of just whole weeks, but really in increments of whole days. With hourly non-exempt employees, you can actually do that. Actually, I was about to say you can do that by the hour. You can do it by the hour under the FMLA. There is a greater increment of time under the FFCRA. So I think employees have to take, in fact, I know under the most recent DOL guidance released Friday, non-exempt employees can take FFCRA leave in increments of as small as 1 day, but not less than that, right? So you can't be out 1 hour to seek a diagnosis, then back the next hour. That may be the case, actually, under the FMLA, not the FFCRA. What kind of notice is required? Well, what kind of notice is required? Same notice under the FMLA. You have to give as much notice as practicable under the circumstances. And I think you were advancing to the next slide, Barbara. And this is still me. Okay, so there's a lot of terminology out there that's kind of, if not brand new to all of us, are getting used in very specific ways. One of my big beefs is furloughs, which is kind of means 1,000 things to 1,000 different people. Let's talk about, though, for purposes of the FFCRA, what some of this terminology means. So we've seen quarantine, we've seen isolation, we've seen shelter in place. What we're looking to is the CDC guidance on this. Okay, so quarantine is taking a sick person or group of people and keeping them physically separate from other people who aren't sick. It's used to separate and restrict movement of individuals who are well from those who may have been exposed to the virus. Isolation it could be, and obviously quarantine can be on an individual or group basis. Isolation is used to separate individuals who are in fact ill, right? Quarantine can be broader than that. So you may be not exhibiting symptoms, and a governor may issue a shelter-in-place order that says we want people in a certain place to self-quarantine. That's regardless of a display of symptoms, although it obviously can coincide with symptoms. Isolation, on the other hand, is where you do have a diagnosis, or at least a strong suspicion, and you're trying to separate that individual. Shelter-in-place doesn't have anything to do with whether you're sick or not. Everybody's ordered to stay home. We're dealing with it in so many different municipalities and states in the country right now. So a quarantine, to boil it all down, restricts the movement of everybody, whereas isolation is specific to an individual. Let's talk about some real world differences. Here's a state quarantine order. Now, most states are not under an actual quarantine order, but in Hawaii, residents and visitors arriving or returning to Hawaii, mandatory 14-day self-quarantine. That means stay in a designated place. In that state, it actually means stay at home, or if you're a visitor, stay in a hotel room. In distinction to that, you've got California, New York, Illinois. They have shelter-in-place orders that is not a quarantine or isolation order. We can leave our homes here, but only for limited purposes. So what it is boiled down to, if you're talking about quarantine or isolation, think of individuals, small groups of people staying in place. If you're thinking about shelter-in-place, it's whole communities under a kind of lockdown. They can leave their homes, but not often. Why does that difference matter? Because under the FFCRA, paid sick leave goes to employees who are unable to work, or if telework is an option, telework, because they're subject to a federal, state, or local quarantine or isolation order. That is not the same as what, for example, Barbara and I have here going on in New York. So if shelter in place was synonymous with quarantine or isolation, then basically everybody who's sequestered in an employer with less than 500 employees in states with shelter in place order would qualify for paid sick leave. That's what I was saying before. Under the FFCRA, it is not intended to deal with the effects of people who are stuck at home as one of the kind of knock-on effects of the entire coronavirus situation. It really deals with attempts to limit illness by keeping sick individuals or groups at home, or keeping sick and healthy people apart from one another. It doesn't apply in shelter-in-place circumstances.
So, and before I move to the next slide, if you think about this, it is a matter of common sense, right? So if an employee is quarantined and is not permitted to leave their home, even to go to what's considered an essential job, they should get some amount of paid sick leave because they cannot go to work. That's as opposed to, for instance, me. If I worked at an essential job, say I had a job in healthcare right now, I could walk out the door and go to the healthcare job. Under New York law, anyone with an essential job can leave and go to work as long as they're not ill. So in your situations, if you are considered essential in your states, and I know the orders have been all over the place, whether construction is essential, non-essential, and it's changed. But if you are considered essential and you need employees to come to work, the fact that you're in a state or a county where there's a shelter-in-place order does not give these employees the right not to come, and it does not give them the right to demand the sick leave under the statute. I mean, it's pretty much that simple, unless their family or they are subject to a quarantine or isolation order. So what if this FFCRA doesn't apply to you? Or let's think about the laws that apply to everybody, regardless of whether you're over or under 500. So if you have over 500 employees or under 500, and this FFCRA applies to you, don't forget about other laws. So a number of states, and we can't possibly go into all of them, and don't worry, we're not going to try. In New York, Colorado, pending legislation in other states have passed COVID-specific leave laws, which are applicable to all employers, particularly like, for instance, the New York law, which went into effect, how nice the state was, it went into effect the day they published it. So you had literally in real time, a day or less to come under these leave laws. So in your states, check whether your state has passed a leave law. Now, what about an employee? In our example, we have an employee, say, who's at home. She's in a shelter-in-place state, so she's not supposed to go to work. You're not an essential business, but suddenly she's found caring for a small child or baby. She's trying to do her work. She's trying to meet her deadlines. And frankly, she can't, because she's holding a baby and typing, feeding a baby and typing, feeding a toddler and typing, maybe homeschooling children. And obviously, I don't want to be sexist. This could apply to a dad also. You have to, again, look at your state and local laws and consider whether this person requires an accommodation because of familial status, which many state laws cover. In New York, for instance, we also have protections for people who are caregivers. Does your state or local law cover caregiver status? And look at the other discrimination laws. So in other words, before you discipline an employee who is not meeting goals or standards or missing deadlines because they're working from home, think carefully about whether in this circumstance you need to be accommodating something about their particular situation, because working from home has a lot of challenges, particularly with people with families and small kids, that they're not facing when they're in the office. And the other thing to keep in mind is a lot of people cannot or do not want to have their regular babysitter come into the house because of the risk of transmission, or maybe the babysitter herself has kids at home and that can't come in. So everybody is in really a brave new world. We also have 6 states, and we've listed them here, that have paid family leave laws. So even if a person doesn't qualify for the COVID leave, even if the person doesn't qualify for the FMLA leave, they may qualify for paid family leave. If you're in one of these states, just consider and talk to HR department or your disability carrier, which in many instances will administer these paid family leaves. And these are, again, the states that have enacted. Now, these are paid sick leave laws, not specific to COVID. So they just apply to anyone who's sick. And if someone is diagnosed with COVID, they're going to be covered by one of these sick leave laws. The thing that the new COVID laws are encompassing are employees who are not sick, employees who are well. Like if my husband, for instance, now was diagnosed with COVID, which thankfully he's not, I'm well, but I would be quarantined with him. The new COVID laws are covering well but quarantined people. But if you've got someone who's got COVID, they're going to be covered by a paid sick leave law. So there's just a lot of overlapping obligations.
Okay, so let's shift into some practical considerations with managing your workforce. If you want to go to the next slide. Hey, Barbara.
Oh, sorry. Everyone working remotely.
There you go. Okay, so everybody's now working remotely in a non-essential business, right? What are the considerations they have to think about? There are a whole plethora of them. And so one of the things we've been telling employers is that, as Barbara said at the beginning, there's obviously an obsession right now with trying to understand and nail and get exactly right all of these recent amendments to laws and new laws being passed. But, there are still wage and hour laws. All of the employment laws that always apply out there continue to apply. So one thing to think about in a remote workforce is, what about your non-exempt employees? How are you doing timekeeping? How are you keeping track of hours? How are you protecting equipment? How are you protecting your technology? Barbara's going to talk a little bit later on about security and electronic hygiene, right? So there's a lot of data flowing out there. There's a fascinating statistic that phishing efforts have increased something like, I've read various statistics, but like 300% with so many people working at home, because now electronic systems are that much more vulnerable. Also, one thing to consider, and we can get into some detail on this a bit later, expenses. So employees who are working at home are incurring additional expenses. So somebody has to run out and get a printer because they needed to work at home. Is that something that you would have to reimburse? Scary answer in California, actually, unsurprisingly for California, is maybe yes. So there's a whole range of issues that you're confronting with a remote workforce that you're not normally thinking about. So what are the practical issues? Well, let's get into that timekeeping issue. Exempt, again, that means not entitled to overtime under federal and state wage and hour laws. What hours should you be on duty and accessible? How are you going to check in? How are we going to measure productivity? This is like changing the tires on a moving car, as I've been saying. And so a lot of employers, including us, are trying to figure out, we were all able to work remotely. from various offices, various hotel rooms around the world at various times. It's a different thing entirely to have 100% of your workforce be in the office one day and out of the office on the next day. So it's incredibly important to create touch points, regular check-ins, and to communicate expectations for people who are working from home. Feels a little odd when people are just kind of, used to doing things on the honor system, but you have to manage employees and say, our day starts at 8:30 or our day starts at 9 o'clock. We expect you to be available by phone and by email. We expect you to be responsive. And frankly, if we're paying you when you're at home, we expect you to be working. Now, with a lot of kids home from school, that can be a challenge. And I don't think this is the time to become too draconian or mechanical in the way that you employ or apply, rather, your HR rules. But those are expectations, long story short, that have to be communicated. Non-exempt employees. This is not just a question of managing the workforce. This is a real question of liability. Every single time somebody does anything for your benefit and they are not exempt, they are working for you and they are entitled to compensation. So if you have exempt employees who are working at home and they're checking email, that's compensable time. So that means that you have to go through all of your regular processes for tracking time, logging time, recording time, getting managers to approve overtime, and again, communicating all of those expectations. Barbara mentioned hospitals. We came up with a policy yesterday where there are actually people going to hospitals for obvious reasons, staffing reasons. There are nurses who are taking care of sick people, doctors, technicians, everybody else. But one of the things we had to say in a policy yesterday where they're going to use email to help track non-exempt time is do not work unless we tell you to work. Don't work outside your scheduled hours unless you're told to work. Frankly, we're going to have to look at discipline if you don't follow those rules. And anytime a manager specifically directs you to work outside those hours, here's how we want you to track that time. It doesn't feel natural from the sort of, looser HR kind of relationship that you want to have with your employees. But again, if those expectations aren't communicated, people are out there without any real guidance, and it's a wage and hour violation waiting to happen. Can we go to the next slide?
Myra.
Okay, so fielding questions. We have an exempt professional. She is exempt. That means she's not entitled to overtime. Claims she can't work because her iPad isn't working. You've chosen not to give her equipment, but you did tell her that a laptop was necessary. She didn't read the email, so she doesn't have a laptop. So should you make her buy one? Should you put her on unpaid status? Should you fire her for not reading her email? There are considerations behind all of these. In some states, you can legitimately make that employee buy one. I think in this case, the most practical solution is if your economics justify it, your finances justify it, supply the equipment that you need for people to successfully work from home. If you don't do that, you get into first of all, just a practical issue of how somebody's supposed to do their job. But secondly, you also get into questions of if you're trying to shift that cost or that burden onto employees, does that become a compensable expense that is compensable to them? Can we go to the next slide? All right, what about, and I think this is still mine, yep, George's Gmail. George is a valuable senior VP. Okay, you can see this one coming, right? You can see what the legal question is. Important to work from home, has to work from home. He transfers customer data to his Gmail so he can print it on his home printer. He's hacked and there's a breach. Okay, we could do an entire 80-hour presentation on how to deal with security breaches, but the bottom line is, can we go back? I'm sorry. Yeah, sorry. So he's hacked and there's a breach. There could be massive liability for data breaches, right? So this goes to the electronic hygiene point. It's incredibly important. If you've got protocols for protecting data, intellectual property, electronic information in the workplace, you have to have a parallel system outside the workplace. Now, some of you as smaller employers may not be set up to have secure, secure systems that can run kind of a mirrored system to what goes on inside the office, but certainly you can use highly secure Dropbox systems and so on. So just remember, I think the big point in here is that data protection becomes not less important, but more important when people are working remotely. Thanks, Barbara. We can go to 35.
I think you talked about expenses.
Yeah, I think we can skip this one.
Okay.
I think you are Sam the Slacker, right?
now he's out working remotely. He's supposed to be handling data entry and processing invoices. He's not on the morning group call. He's late with invoices for the day. You call him at 10, he calls you back at 4:30. But now he claims he needs overtime because he's just getting to process those invoices from the morning. How do you handle Sam? I think the answer is just the way you'd handle Sam if he disappeared for 6 hours in the middle of the day. You would document it and you would discipline and you give him a warning, right? You have to be clear with remote workers, and we've done this at our firm, and we've done it, helped a lot of clients through it, that they have to understand the hours. They have to understand that they can't be using public Wi-Fi. They have to be using devices you issue to them. They have to be careful with physical confidential materials. And going back to Sam for a second, if you're working remotely and you're called at 10, you should be returning that call within half an hour unless you're on another business call. There is no excuse for him not returning the call till 4:30. And that's where it comes to, as Mark said, setting parameters and setting hours. So even if you didn't have to do that before, you have to do it now. You should be at your computer from 8:30 to 5 o'clock, and you should be on the morning call at 10. And when I send you something, you should be responding back. And we've had to do that with a number of our employees, especially the people who are non-exempt and entitled to overtime. And then we have the nervous nester. And I've seen that with a number of clients who have essential businesses, and many of you are in this circumstance. So he's not scheduled to work, but he's called in to assist with a project because you've had significant call outs, significant delays, and you need to get the thing back on track. He refuses. He says, you know what? I'm nervous. I'm not sick. I feel okay. You ask him if he has a temperature? No. He just refuses to come in. Can you terminate him? Do you want to terminate him? The answer is, generally speaking, unless he has a medical reason for not coming in, simply being too nervous to come to work is not a reason not to come to work if you're in an essential business. So yes, you can discipline him. Would I fire him on the first instance in this environment today? No. I would ask him why. And we've had people with interesting, and in some cases, rational reasons. I'm not sick. I'm not subject to an order of quarantine, but I'm living with elderly parents, and I am afraid of bringing the virus home to them. I'm living with a child who has an illness and is immunocompromised. I'm afraid of bringing the virus home to her. That becomes a little more difficult and nuanced conversation. But if the guy or woman is just nervous and they don't have a legitimate reason for not coming in, discipline is the answer.
And I would just add to that, I think we're finding it particularly under this phase of the crisis, where numbers are still going up, not down. Testing is not widely available. We would love to tell you the hard and fast set of rules for what you can insist on and when you can fire people or otherwise discipline people for not following that set of hard and fast rules. The reality is, everything we're saying are guidelines. I mean, obviously the laws are the laws, but within those guidelines, it is really important probably to approach things on a case-by-case basis, because as Barbara says, I myself have been surprised. My gut reaction is, look, we're all afraid. It's inherently risky to walk out the front door nowadays. That's not a sufficient reason. When you dig in a little bit, as she says, there could be that sick family member at home. So try not to have kind of a completely lockstep approach to this. And I think it is important to inquire into specific reasons and draw information out of employees when they express a concern.
And look, you've probably been told this before by employment lawyers, but if you decide to discipline or not, whatever decision you come to, you have to write down why. You have to document why. So if this person sues you 6 months from now, you have a defense. I mean, the lawsuits aren't going to come now. Everyone is too freaked out to be suing anybody. They're just trying to keep their jobs. The lawsuits are going to come later. And people who were disciplined or they feel were treated unfairly, I think once all this dies down, everybody holding hands and singing is going to be over, and everyone's going to be suing each other. So document why you're making tough decisions. Now we have the opposite of nervous nester. We have Hank, the hero, okay? He comes to work and reports to his coworker that he's got a fever and he's got body aches. But he's there because he's the project manager and he has to be there. He's been using personal protective equipment. But who knows how sick he is, okay? What do you do when the coworker comes to you and says, Hank is telling me that he's got a fever and now everyone in his department is freaking out? The answer is you can do quite a bit because the law allows you, for instance, to take his temperature. That's one thing that the EEOC has stated, which wasn't the rule a month ago. The law allows you to question him about his symptoms. And if you believe that he's experiencing symptoms, and you can find the symptoms on state and federal websites at this point, that you can almost do a checklist. If he's experiencing those symptoms, you can send him home. Why? Because the EEOC, the Equal Employment Opportunity Commission, has decided that COVID-19 and the presence of symptoms presents a direct threat to the health and safety of your workforce. And that's a very important phrase. So whether you look at it as a disability issue or you look at it as OSHA, the ability for you to give the rest of your workforce a safe place to work, you should be sending someone home if they have symptoms. And the likelihood that he will be able to sue you is quite small. It doesn't matter whether Hank is a project manager or just a construction worker. And you're going to get the flip from an hourly worker. Hank, my project manager, is coming in because he's really devoted to getting the project done. Hank, the construction helper, he's coming in because he can't lose the hours. Maybe he doesn't qualify for the paid sick leave. Maybe he doesn't have any paid sick time. He just needs the money, okay? And we've seen this with people at all levels, receptionists, secretaries, what have you. Unfortunately, they should not be coming to work sick, and you should force him to go home. If you force him to go home, does he have to be paid? It depends on a combination of your state laws. Like in New York, yes, the answer would be yes. Federal laws, is he covered under the FFCRA? And your policies. Do you have PTO policies that would allow him to take PTO?
One quick footnote, and I know we need to keep moving before I get into furloughs and layoffs, is confidentiality of information, right? So in that whole hypothetical Barbara just went through, Hank is trying to be a hero. He's not self-disclosing. It's a coworker that says, I think there may be concern here. Okay, fine. So you're having that interaction with the coworker. But remember, the medical information that's being gathered is still theoretically covered by HIPAA. There could be some real employee privacy concerns. So it is much better to have that conversation directly with Frank and keep the conversation confidential. So now let's shift into layoffs, furloughs, what you should be thinking about. We can go to the next slide on that one. All right, so what is a furlough? There's a lot of confusion out there because this word gets used in lots of ways. So unlike the word layoff, which actually occurs in federal law, so for example, the WARN laws that require notice in advance of termination for a mass layoff or pay in lieu of that notice, there isn't any word in federal legislation that we've known up until now that refers to a furlough. So this is more just an HR common sense kind of word. A furlough is just a temporary layoff of all workers or some of them, and it can involve lots of different things, right? There are different flavors of this. Reduced hours, reduced days or weeks. If you're an airline, none of you are, but in that industry, it actually means letting a whole group of employees go for a period of time, but telling them, we expect you back by date certain. So for an example, we have Mike, the manager. The company, we have to suspend production and furlough everybody on the line until May 1st. We can go to the next one. In that example, that's only one species of furlough. So when employers have been asking us, hey, we're going to furlough employees, what does that mean under the FFCRA or some of these other paid sick leave laws or whatever? Our first question is always, well, forget the label. Tell us exactly what you're doing with the workforce. Is there going to be employment loss? Is there going to be a reduction in hours? There are state unemployment insurance laws that get triggered if hours fall below a certain level. It really depends on the specific facts. What are the biggest issues in any layoff and any furlough? Pay issues, right? Exempt versus non-exempt status. You have to consider about whether these WARN laws that I mentioned a moment ago apply to you. If an employment loss actually gets triggered, you have to worry about compliance with the FFCRA. If the reason is an FFCRA covered reason, again, there could be overlap there. And you also have to worry about potential discrimination claims. So when employees are suspected, let's say, of being ill, that's potentially a perceived disability. And employees may be, again, we're going to always advise employers to err on the side of safety. But when you were just, if you're saying, look, I just view that employee as sort of higher risk, I want them out because I perceive them as, I don't know, coming from a segment of the population or a part of town where there's likely to be, a higher risk of coronavirus, outbreak or infection, there could be potential discrimination claims in there as well. Let's go to 45.
And remember too, if you're not laying off every person in a particular company, department, job category, so I'm going to use this opportunity to get rid of Sarah because she was a poor performer. Just because we're going through this COVID thing doesn't mean that Sarah can't sue you for age or sex or whatever kind of discrimination if she thinks that she was really being laid off because she's a woman or because she's over 50 or whatever reason. You're still
Right.
subject to all those discrimination.
Right, and even in a RIF, in a larger scale RIF or a real mass layoff of a group of people, you still want to run through the usual considerations that you run through. What are the age impacts? Could there be a potential age discrimination claim here or some other form of discrimination claim? Are there legitimate business reasons behind all of the decisions we were making? And can we document those reasons, or have we created documentation to support those reasons? So if we do get a discrimination claim on the back end, can we support the termination? Same as any other termination pre-COVID crisis. So what's the advantage of a furlough, a temporary layoff? Well, most versions of furloughs don't involve employment losses. There may be a reduced work schedule, reduction in hours, potential reduction in pay. So why would you furlough? Precisely because it doesn't involve an employment loss. When there is a mass layoff, and we're not going to get into all the details of Warren statutes, there's a federal version, there are various state versions. If enough employees in a group are let go at the same time, sorry?
We're doing more in a minute.
Yes, indeed. So when enough employees are laid off at the same time, it triggers pay in lieu of notice or notice in advance of that termination. There may also be some Warren exceptions, and you want to go to 46?
Mm-hmm.
So again, let's stick for a moment with why would you do a furlough? There are skilled teams or individuals that you don't want to lose, right? So you're going to offer them a more reduced hours or reduced pay, but you want to keep them employed because you need them. They're essential to the operation. Here's another huge reason. When people remain employed by you under the Affordable Care Act and otherwise, there's an obligation to extend health benefits to them. So when you have people out on the street, when they really do have a true employment termination, all of a sudden they don't have benefits either at a time when they may need them most. Another reason, this is particularly true in unionized environments, but just really in any employer, you want to maintain service credit for benefits purposes or pension purposes or seniority. And look, here's a critical thing too. The hope and expectation is that we will eventually recover from this, and hopefully sooner rather than later. Employees would much rather take a reduction in hours and the commensurate loss of pay right now and keep their jobs than have an offer for a rehire after being out of work for 3 months with no wages at all and no benefits. So there's an important component to this where you may not be able to maintain employment for a certain number of individuals, but where you can from an economic perspective, it makes a lot of sense to do that for all those reasons. Now, on the other hand, a layoff may be more appropriate where there is such a significant downturn in your business, you have no expectation that somebody's going to be rehired, and you don't want to give them that false hope. It also frees that person up to find a new job if they can. And of course, from a cost perspective alone, benefits is usually about a third of the cost of payroll altogether. So there's no requirement to continue benefits if in fact the employment relationship has ended rather than has been modified through some furlough. One more for me. All right, payroll issues. We got Mike the manager. He is exempt. Again, that means not entitled to overtime. If he's checking email or coming in a few hours to check the building, the company may have to pay him for the full week. Why is that? Because if you start subdividing Mike the manager's hours as if he were paid by the hour, you suddenly risk losing the exemption status, right? In other words, he may suddenly become eligible for overtime. Non-exempt workers, you don't have to pay if they're for a particular hour if they don't work during that particular hour. Again, this relates to furloughs and not a true layoff where people lost employment. So if you're talking, what's the takeaway here? If you're talking about a modification of schedules, just remember that when it comes to your exempt employees, you may have to pay them for the full week, or you risk treating them like an hourly employee who's entitled to overtime. Non-exempt workers, much simpler. Pay them for the hours that they work. You don't have to pay them for the hours that they don't work.
And before I move on, and I'm going to cover WARN very briefly or in a very succinct way, I do want to give you all a warning under WARN. These slides are not a complete description of any of these laws. They are summaries and really talking points, so please do not treat them as the legal Bible, because they're not. I mean, the law, the FFCRA law, for instance, was, I think, over 40 pages. The FMLA has hundreds of pages of regulations. So these are summaries and talking points, and don't treat them as your legal Bible. If you get into a tricky situation, you really should consult counsel. So there's a federal WARN, applies to companies, any employer with 100 or more employees, but there are state laws that lower that number. In New York, for instance, it's any employer with more than 25. If you have a mass layoff or a plant closing, you are supposed to give 60 days notice to all of the affected employees, to unions, and to the government. Now, a mass layoff is basically an employment loss of at least 33% of your employees and 33 and 50, or 500 at any site. A plant closing is a layoff of 50 or more, excluding your part-timers, at a single site, which results in a closure or shutdown of that site. Now, I know you're all sitting there thinking, this woman is crazy. If they told me to shut down, how can I possibly give people 60 days notice? Well, I may be crazy, but that is the law. Now, are there exceptions? Yes. Is there a pandemic exception? No. Congress has not created a WARN pandemic exception, even with all of the hundreds of pages of legislation they're passing. And I really question why they haven't, why they just haven't come out and said WARN shouldn't apply, because there are lawyers out there trolling around for clients. Now, there is an exception called unforeseeable business circumstances. It's generally been applied to natural disasters like hurricanes, floods, things like that. There's no regulations or guidance on pandemics. I think a government shutdown, if you work, one court is not going to find that that's not subject to a WARN exception. I'm just telling you that you should be aware of it, because no court has held that, and they haven't come out and said that as a matter of congressional fiat. Would someone sue? Absolutely, yes. All right. There are plaintiffs' attorneys who are out there looking for clients. It's crucial that you ensure, if you think you're covered by WARN, that you consult a lawyer and determine whether you are covered and whether there's any way that you could have given any portion of the notice. State mini WARN laws, for instance, California, I talked about New York. New York covers any mass layoff of 25 or more employees if those employees make up 33% of the workers at that site. So it's a much smaller number. So just be aware of your states and watch for state guidance. You know, the last thing you want to have happen in any of these circumstances, whether you're talking about a layoff or a furlough, is to have a plaintiff's lawyer sue you and eat up all of the money that you thought you would save in employee salaries in damages, legal fees, and all of the headache that goes along with that. And I will add, the biggest reason to furlough, I think, over layoff, and we've had a lot of large companies go to furlough instead of layoff, is they really believe they're going to reopen. I mean, Macy's just furloughed. Why? Macy's, I'm sure, hopes it's going to reopen. And so everyone is still on the payroll. No one's being formally terminated. And hopefully when the stores reopen, they will just contact those employees and bring them back without going through all the formality of rehiring. And that's, I think, the biggest reason in this circumstance. I think it's different if you're in a business where you have gone bankrupt and you have to liquidate and you really don't think you're going to bring those people back. Damages are significant under warrant. You have to pay 2 months' pay, 60 days of full pay for hourly employees, fines up to $500 a day, plus attorney's fees to the employee lawyers. So it can be really, really significant amount of money. Now, one thing that I have had clients ask about, and I think can be really effective, is what about an alternative to firing everybody or furloughing everybody? Could you require everyone to take a pay cut? So we, the company, are going to do a 20% pay cut for everyone at the management level or for everyone across the company. The answer generally, unless you're subject to a union contract, is yes. Unless you have employees with individual employment contracts, you could do that. And a lot of people would, I don't think anyone's happy with a pay cut, but a lot of people are okay with a pay cut in this circumstance if it means their colleagues and friends are going to keep their jobs. Could you reduce an hourly rate for the non-exempt employees? Yes. Again, make sure you're not discriminating. Make sure you're not just doing it for the men as versus the women. Make sure you're doing it in a consistent way across job titles. But it is a good strategy instead of a furlough or a layoff. Check contracts and check your state laws. But the general answer is that is a good thing.
Hey, and I'm just going to jump in 1 second and say, I know, Barbara, you're going to wrap it up now. We also have gotten a whole lot of questions, and we will be able to go through some of them. I can read them to both of us. So you want to take us home, and then I'll get into some of this stuff?
Yeah, I mean, this slide is a resource for all of you. The CDC guidance is very helpful on risk assessment, on coronavirus, and it's something to look at if you have employees coming into work, asking you questions. I think the employee travel is actually getting a bit outdated because, they're saying you shouldn't have traveled to China or Japan. At this point, people are saying that you shouldn't travel to New York. So I'm not sure all of that really applies as much as it did a couple of weeks ago. But these are websites and links that I think will be very helpful. And as we said at the beginning, we're going to now try to answer some of the questions that have been coming in and get your answers to.
And there are a whole bunch of them. So the best we can do is, frankly, pick some representative ones. I will say just very, very quickly, my favorite one so far is, what is our record number of questions being asked for copies of slides of a presentation during the presentation? I think this actually beats it. And that was about 72 of the 503 questions.
Well, I think we should have started by saying today you all are setting, I think, our personal record and a Kelley Drye firm record. I think we had about 1,500 people sign up for this presentation. So thank you all, and I hope you've enjoyed it. But
so there you go.
Had a record for us.
Yep, thank you. All right, here's one question. I can take it, and then I'll throw one to Barbara. Do furloughed employees receive unemployment benefits? So obviously, if you're terminated, if you have no more job, you are eligible for unemployment benefits, assuming that it was no fault of your own that you were terminated. Unemployment is a question of state law. So for example, in the state of Ohio, if you fall below, I think it is 25% of your regular pay, you're entitled to unemployment. In California, I think that number is 20%. I may be mixing the two states up. So there are different thresholds in different states. Long story short, on a state-by-state basis, reduction of hours can qualify a worker for unemployment benefits, and it really just depends on which specific state law you're talking about. Okay, we've gotten a bunch of questions about when a furlough makes sense. So
I can take this. I mean, I think a furlough makes sense, as I maybe was saying earlier. If you are confident or reasonably confident that you're going to reopen, and especially if you have highly trained staff that you want to keep the team together, that's when a furlough makes sense. First of all, I think it imbues the employees with a sense of loyalty. We're not firing you. This is just temporary. We're going to get through this together. Maybe you're able to keep them on benefits. And I think the employees will, generally speaking, especially if they like the job, will stick with you. I think that's when a furlough makes sense as opposed to a layoff.
Yeah, that's right. And many of the versions of these questions are, what if we can't afford to furlough? Well, I mean, I think the short answer is you can't afford to furlough. You can't afford to furlough. There are benefits to maintaining the workforce. There's going to be a point at which that's economically unsustainable for you as a business, for any business at some point. And, that's a situation that obviously each individual business is going to have a decision that each individual business is going to have to make on its own.
Reality today
Sorry?
is, I would say the reality today, I think, is whether you call it a layoff or a furlough, the possibility that employees are going to get other jobs in the next, say, 6 to 8 weeks, and I'm hoping we're back in operation in 6 to 8 weeks, is relatively small. So if you keep their contact information, whether it's a layoff or a furlough, hopefully you'll be able to get them back.
Okay, here's one for you, Barbara. Do any of these laws apply to employers with fewer than 5 employees?
Well, the Families First Act does. I mean, it applies to every company with under 500 employees, whether you have 2 or 498. Now, there's that under 50 exception that we talked about. And for instance, if you were in New York, the new paid sick leave law applies to all employers. So could be a state law or it could be the Families First Act.
Okay, here's another one. I have several friends who think they have COVID-19. Oh, darn it. Every time a new question comes in, it scrolls right to the bottom and I lose the question. The question was, essentially in circumstances where somebody can't get a doctor's note, how are they supposed to demonstrate to an employer that they have COVID-19? Look, I think the reality is, and again, this is similar to a situation I dealt with this morning. If somebody goes to a doctor, the doctor may either diagnose them with COVID-19 or say, I don't know if you have COVID-19, but I want you to stay home and self-quarantine. Either one of those circumstances is covered by the FFCRA if the law otherwise applies to you. So, however, to the point of that particular question, an employee's been to a doctor, so it's okay to ask for a doctor's note. In fact, it's, you can require them to provide a doctor's note. You don't have to take employees' word for it. We do worry about leave abuse. And so, I think employers should follow the normal HR policies and procedures, which if somebody says they're out sick, you can ask for a doctor's note.
I mean, I think the Department of Labor just came out with guidance on Friday where they talked about inability to get a diagnosis or get an order of quarantine. And what Department of Labor said is you can accept a doctor's note and the employee has to bring the order of quarantine in 30 days. Now, to Mark's point, if you believe you have coronavirus, and I know this for a fact because of all the doctors we represent, you can go on a teledoc, meaning you can contact your doctor electronically and that person can supply you with a note. So even if you can't physically go into the office or they tell you not to go into the office, they can give you a note. And then you can follow up and get the diagnosis. So I think giving them a reasonable amount of time, it doesn't have to be today. Get it to me by Friday, get it to me by Monday, but they should present you with some proof because there is going to be a certain amount of possibility of sick leave abuse, particularly with this new law and 14 days of paid sick leave.
For the person who keeps asking me whether there will be copies of this presentation provided, the answer is yes. I thought maybe I was too snarky in my response before, but yes, a recording of this presentation is going to be made available to everybody. All right, here's one. If a non-working spouse is at home with children but doesn't feel capable of helping with the homeschooling, does the FFCRA Act allow... Does the FFCRA law allow the working parent to stay home to help with the schooling if schools are closed?
Yes.
Yes.
I had, how we had this question? I mean, the law was written very quickly, frankly, over the course of a weekend. You could have two, one non-working spouse, one working spouse, and the law didn't say that the person taking the 10 weeks of leave had to be the primary caregiver. It's just either parent. So I think what you might find is people saying, I'm going to take a week here, my wife's going to then take a week, I'm going to take a week, because they can share it or they can take it together. So both parents could be home and qualify for that 10 weeks. Remember though, we didn't get into the numbers, it's only $200 a day It's not full salary. And obviously it depends on how much the person makes. The maximum amount of benefit for the 10 weeks is $200 a day with a maximum of $10,000 for the child care benefit. It's not a ton of money.
Right. Here are a couple more. All right, here's a good one. I have a doctor's note from an employee for days off in March. Are we required to pay them leave? And the short answer is no, because the law didn't become effective until April 1st. Barbara, I think you don't have a different view of that, right?
It does not have retroactive effect.
Right.
So,
okay. Again, it's very, very hard to read this dialog box. All right, everybody just stop sending questions for 1 second so I can actually read one from beginning to end. For an employee that fits under the FFCRA requirements, would an employee that provided a doctor's note to self-quarantine because of being high risk with an underlying medical condition, not because they're having symptoms, qualify for paid sick days or paid leave? That's a good question. So what if a doctor tells you, I need you to self-quarantine, not because I think you have COVID, but because you're particularly high risk? I think that's covered by the FFCRA. The language of that particular section of the statute doesn't say under a doctor's order of quarantine, because you are sick. There's sort of no qualifying language. It's if you have a doctor's order staying home, ordering you to stay home and self-quarantine, that's a covered reason.
I mean, I think Mark is right. I've gotten a lot of clients with pregnant employees getting doctor's notes because the doctors don't know whether pregnancy makes you more susceptible. They don't know whether it crosses a placenta. And so a lot of doctors are advising their pregnant patients just not to leave the house, not to go to work.
Yeah. Here's one question. Do we have to pay them, I think they mean employees, during the entire furlough? And again, that's going to depend on exactly what furlough means. But if furlough means reduced hours, like we were saying, if people are working, you have to pay them. So you don't have to pay people for time not worked. There's obviously a distinction between the way that you'd have to pay exempt employees, which is generally by the week, and non-exempt employees, which is generally by the hour. But yes, when employees are working on furlough for the time that they work, you're going to need to pay them.
But Mark, let me clarify something because I want to make sure we didn't confuse everyone.
Sure.
Or furloughing. You could be furloughing and saying nobody's working. Nobody's working. Okay.
Right.
You go out, you're not working, and you're getting nothing. So I think one of the questions earlier kind of concerned me because I thought maybe we confused them. We can't afford to furlough. You can afford not to pay anyone. So, my brother, for instance, has a small construction company. Actually, he's a solar energy provider. He furloughed 30 employees. He's not paying anybody, paying zero. Okay. He hopes to bring them back because they're a talented crew. But if you can't afford to pay people, you can put them on furlough and pay them nothing. In that event, in your state, they may qualify for unemployment. And the enhanced unemployment under the new CARES statute is quite generous. It's, I think, $600 a week more than what your state provides. So you don't have to pay people while they're on furlough. It was a long way of saying that.
Yeah. Here's one. If the state has a family leave law, so let's say a paid family leave or paid sick leave law, does it supersede the federal leave law? No. I mean, so generally speaking, state and federal benefits are going to run concurrently if they're for the same reasons. But it's not like, if you have a state paid leave law in place that it would somehow supersede, or sort of go over the head of the federal law. So if you have a condition that's covered under a state paid leave law and a condition that's covered under the FFCRA, simultaneously, the way those state laws are generally drafted is that they don't get to sort of piggyback one period of paid leave on top of another period of paid leave. However, the laws do cover different reasons or different circumstances. And in those circumstances, in a situation like that, you could be out on leave under the federal law for one reason, and then later be out on paid sick leave under a state law for another reason. Okay, let's do a couple more. It's actually hard to fully keep up with all of this stuff. Bear with me. If here's one for you, Barbara. If an employee lives with an elderly parent and is choosing to stay home out of concern for the parent's health, Do they qualify under any of the grounds of the FFCRA?
No, I don't believe so, unless a doctor has issued an order of quarantine, and I don't believe doctors are doing that. I've had this request, and actually what we advised the client in that circumstance was, it's really a personal choice. So I wouldn't, you really can't force someone to come to work. I think it's harsh to fire them in that circumstance, but you can place them on an unpaid leave. It's a personal leave of absence. They can use their paid time off if they have a vacation bank that they want to use up. But I don't think they qualify under even our state sick leave statute or the FFCRA. If it's just an elderly parent, different if the elderly parent had COVID-19, different if the employee had it, but just out of concern, no. I mean, what employees are doing, frankly, if they're in that circumstance and they want to still work, is they are finding a way to separate themselves from the family member, sleeping in a basement, basically separating themselves within the home so they minimize the contact. But I don't think you're required to give them the time off.
Yep. All right. So I think probably we're getting close to 1/4 past the hour. We'll have time for one more. There are, well over 100 questions that are still outstanding. So we're going to have to get back to you on some of these. But let's.
Well, Mark, there's one. I just miraculously figured out how to read the questions.
Okay, great.
One I think we could clarify. So, and this might apply to everybody. Does time off from a state executive order requiring stay at home apply to this? If we didn't clarify this, let me make sure we did. No. Okay. Everyone in the state of New York is now at under a stay-at-home order. We are not all entitled to paid sick time or paid COVID leave under the different laws. It's only if you have an individual order of quarantine or isolation that applies to you, your family, Barbara, Mark, whoever. And there are people coming forward and saying, I need this because we all have to stay at home. No. So I hope we made that clear.
Let me interject right now and say thank you, Mark and Barbara, for your excellent presentation. For those of you who are still on, I want to make sure you know that this has been recorded and will be made available to you as soon as practicable. We will also make the slides available to you. I want all of you to keep something in mind. All of this is new, and there's a lot of information to process. In the abstract, and particularly for many of you who have not had to deal with FMLA, this is like a foreign language. But you have resources available to you. Again, the NAHB website that has those resources is www.nahb.org/coronavirus. Check it out regularly. There's updated information, articles, webinars, and other resources. Mark and Barbara's contact info will also be available. You should not hesitate to contact your insurance agent to help answer some questions about the coverage that you provide your employees. Keep all of this in mind. We're going to get through this and we're going to be stronger for it. Take a deep breath, take care of your families, and of course, wash your hands. Thanks for being with us.
Thank you, everyone.